Last week, the Supreme Court ruled that former Minister of the Niger Delta, Senator Godswill Akpabio, be included as a senatorial candidate. Later this week, the Supreme Court will also rule in the case to determine whether Senate President Ahmad Lawan will be a candidate for the Senate election. These decisions have raised concerns about the role the Supreme Court will play in the electoral process. Will the courts introduce another level of uncertainty in spite of the innovations introduced by the electoral law? How will all these affect the 2023 elections?
And to help us provide some answers to these questions, we're now being joined by Arise News analyst Dr. Sam Amadi. Dr. Amadi, thank you so much for being here. You know, the Supreme Court, the last time we had all sorts of rulings like this, especially sort of controversial ones. If you cast your mind back, Imo State gubernatorial elections, and you know, we know how that played out, and even that of Bayelsa State. But here we are again, looking to the Supreme Court to help Nigerians decide who will be candidates for senatorial tickets. Talk to us about, you know, the role of the Supreme Court and its impact on our electoral jurisprudence.
Well, first, we thought we escaped this involvement of the Supreme Court. Usually, democratic theories will say, look, the less courts are involved, the better. And what that means is that you want to have some level of certainty going to an election. So what we see now is that some candidates are campaigning and they're not even sure. In fact, as we talk, the Federal High Court December last week removed the House of Reps candidate for Ngobala Abombise for the PDP. In this case of former Governor Akpabio, the critical issue is the new Electoral Act kind of removed the discretion of party leaders in terms of determining who is a candidate. To the extent, because part of the mischief that INEC and others wanted to solve through the Electoral Act was the fact that oftentimes party leaders sit in their rooms and write and decide who is the candidate. The court's usual stance is that we will not impose candidates on parties. But that overlooks the fact that the party as an association with members, oftentimes the party leadership is not the party itself. Okay, that's number one. So the Electoral Act says, look, to be validly elected, you have to fulfill these conditions, democratically elected. Now the question that the Supreme Court handled was to say, look, primarily say, we're not going to impose candidates on the party. It's my view, and the view of some other scholars, that this seemed to undermine the policy in the Electoral Act. The policy is to ensure that party leaders do no longer impose candidates. So INEC has to monitor primaries, use the language democratically elected candidates through a primary INEC monitors. So what that does is to open it up to the fact that if a candidate emerges contra to the Electoral Act and the party's constitution, it's no longer a question of deferring to the party. In my view, the courts ought to arbitrate that contention, because the same Supreme Court used to decide who is the proper general overseer of churches. Many cases have gone to the Supreme Court. We have people who are contending for headship of churches, church associations, go to the Supreme Court. The Supreme Court make determination. Now, the political party is like an association, just like the church. But what has happened here is that they are registered under the law to contest election. And the Electoral Act has now provided that he must be democratically elected with all the safeguards and the requirement of INEC supervision. So my view generally is not just about the facts of Akpabio's case, because some people might argue that maybe INEC had some shoddy, lack of clarity in their process. But the question is, should the Supreme Court throw away their hand and say whoever the parties bring up is a candidate? Now, don't forget, there's a case coming up. The Senate President himself,
who has lost,
who did not participate, so to say, but the party seemed to want to be on the ballot. How would the Supreme Court look at a case where somebody contends that he actually won the primary, supervised by INEC with, according to the Electoral Act, and the Supreme Court says, and the party leader say, maybe we want Mr. A, not you, who won. Now, would the Supreme Court use the same logic? which I fought.
So the question here, Sam, is how wieldy or unwieldy is the Supreme Court judgment in the Akpabio's case, particularly when you score it against a subsisting ruling of the Supreme Court which leaves the party as supreme?
So the point, therefore, we are arguing that the new Electoral Act has shifted when the Supreme Court, starting from a long line of cases, says the party does not impose a candidate. The electoral regime then did not constrain parties on how to elect their members. So in the previous electoral regime, the parties submit the candidate they want. And the Supreme Court maybe rightly says there are no formal legal requirements of due process. But now, and the Supreme Court says, they didn't just say the party said, they says the party's internal rules govern. Now, when the party's internal rule is now superimposed with the Electoral Act requirement of democratic election and the requirement of INEC supervision,
that should be reconciled.
It changes the game. So the law, the substantive law, has imposed a duty on parties to comply with the substantive law. So the Supreme Court can no longer, in my view, say that we defer to party leadership. The Supreme Court will only defer if the party leadership has met the requirement of law. And this is even the U.S. Supreme Court. I mean, in the case of all regulatory issues, they say if the party or anybody has followed the law legally, reasonably, we can't upset it. But if you had violated the law, if you have not decided, the party has not made their selection based on what the law requires them to do, then the Supreme Court cannot say it's an internal affair. That's the point I'm making. Logically, the election of a candidate under the new Electoral Act is no longer an internal affair of the party. It's now a public affair because the law has said this is how you should do that.
Okay, thank you for that clarification of the Electoral Act. But at the end of the day, when it comes to election matters, it's supposed to be about the will of the people, not necessarily about a court of competent jurisdiction, which we're not arguing here.
Point, yeah.
But at the end of the day, if we're seeing all of these litigations go all the way to the Supreme Court to even decide candidates, some have this fear that, you know what, the courts will be inundated with so many cases that this electoral cycle, the court should get ready. Would you say this fear is palpable and justifiable?
Unfortunately,
from what we are seeing
what
so
I
far?
said, the court will be happy. The Supreme Court will say, bingo, that's what we're talking about. That we don't want to be the one making the decision. So you may be right, but look at what should be. The jurisprudence of the Supreme Court should be the one that says, we're going to always look at what is the will of the people. So in terms of party management, if the people vote, that's what the Constitution says, they should vote in direct election, they must vote. The delegates will be those voted by the party members. If the people have made a choice, then the Supreme Court gives up. But if the leadership has truncated the choice of party members, our view is that part of protecting the legitimacy of democracy is for the court to intervene. And the same with the bigger election. So if you do the general election and evidence show that the people chose Mr. A, for example, what happened in Imo senatorial election in 2019, where it was alleged that a candidate, under some coercion, wrote the result. The Supreme Court can't allow that to say, oh, we leave politics.
Well, he's still a 7th senator.
They have to insist that the will of the people has to have. So the point for the Supreme Court in this jurisprudence is simple.
Right.
Try to find out the will of the members of the party, the will of the electorates. Let not the party leaders substitute their own preference for members of the party's preference. And let not nobody substitute the preference of the voters themselves for that of either the court or the party leader. So democracy means that the court should defer to what the people want. But in doing that, the court should ensure that a few people do not hijack the party, structure to impose their minority will. That's, I think, is the safest way for the jurisprudence of the party.
It's the safest way, really.
Absolutely. Dr. Sam Amadi, our democracy, of course, it keeps getting better and better.
More complicated and more complicated.
And lawyers find the loopholes and just, well, Dr. Sam Amadi, thank you for keeping us updated so much.